how do you know or how do you show that someone is lying? And I think what she meant was lying in trial on the witness stand. How do you show that somebody's lying? And I think like a lot of people, they'll see these shows on TV, and somebody who, like, okay, well, there's what? So there's Tom Cruise, A Few Good Men, that had Jack Nicholson up there on the stand, and and he's asking questions, and finally Jack Nicholson, you know, you can't handle the truth, all this kind of goofy stuff. Which, yes, can you show that someone is a liar just through amazingly good cross examination like that? Of course, yes, you can. Is it exceptionally difficult to do it that way? Yes, it is. And you never know how that's going to go, in trial, just like Tom Cruise had no clue, how Jack Nicholson was going to testify in that situation. But, you go for it. There's an easier way to do it. Okay. Here in Texas, in civil cases, we have depositions. So what's a deposition? A deposition is an opportunity for the plaintiff's lawyer and the defense lawyer to take sworn testimony from a witness in a case. So a lot of people think, okay, well, the witness is the person that caused the car accident, or the witness is the person that didn't cause the car accident. Okay, well, those are obvious witnesses, but there are other witnesses, doctors, the doctors that treated either one of these people can be witnesses, expert witnesses that testify about who caused the accident, they can be witnesses. All sorts of people, they need to be relevant to the car accident, can be a witness. So as a lawyer, when you're in trial and one of these witnesses is on the stand, how do you show that that person is lying? Okay, we go back to the deposition. A deposition is a sworn statement taken of a witness. When do depositions occur? They occur anywhere basically between the filing of a lawsuit and getting an answer and the trial, or more accurately, whenever the discovery deadline closes, which is usually a couple of months before the trial. So that period of time, you can conduct discovery. That period of time here in Texas can be 9 months, 12 months, 18 months, 24 months, a lot of time. Plenty of time to schedule a deposition of a witness. In most cases, there's numerous depositions. So what happens? I will notice up a deposition of, let's say, a bartender in a dram shop case. So I'll notice them up to appear at my office at 9 a.m. on some day. And I will ask the bartender, okay, so please state your name. Boom. What do you do for a living? I'm a bartender. On such and such a day, were you a bartender at this bar? Yes, I was. So you were working on this day? Yes, I was. And so do you remember serving my client, Billy? Do you remember serving Billy that evening? Yes, I do remember serving Billy that evening. All right. Do you remember how many drinks you served Billy? Yes, I served Billy 9 drinks that evening. All right, great. And so then the deposition will continue, could go on for 30 minutes, an hour, 2 hours, whatever it is. But I got that testimony. It's sworn testimony. In other words, at the beginning of the deposition, the bartender swore to tell the truth, the whole truth, and nothing but the truth, so help you God. I also asked him at the beginning of the deposition, are you on any prescription medications, any type of medications of any sort that would mess with your recollection, that would mess with your ability to be truthful and honest and accurate in your deposition? We'll get the, and yes, there's no medications, there's nothing preventing me from being truthful and accurate today. Okay. All of that happens in the deposition. And then a month or 2 months later, I'll get a copy of the deposition. This is a notepad, but we'll pretend this is the deposition. I'll get a written copy of the deposition, say 8 weeks later, from the court reporter. And what the deposition is, this is a transcript, and it's an exact copy of or communication of the question that I asked and the answer the bartender gave. Question that I asked, answer that the bartender gave. Question, answer, question, answer, question, answer. And that's the format of the deposition. And typically there'll be hundreds of pages of the deposition transcript, maybe even thousands. Sometimes depositions can be very lengthy. But the form is question, answer, question, answer. That's the format. So, all right, now let's fast forward to the trial. We're trying the case, and I have now put the same bartender on the stand. And I've reread the deposition that I took of this bartender 9 months ago. So I understand exactly what's contained in this deposition, and I have the entire deposition marked up so that I know where, what page and what line number the question and answer is pertaining to whatever the subject is that I'm going to talk to the bartender about in trial. So I get to that part of the trial, bartender's on the stand, and I ask him or her, how do you remember Billy coming into your bar on such and such a night? He or she says, bartender says, yes, I remember. And do you remember serving Billy that night? Yes, I remember Billy at my bar, and I remember exactly what I served him. You remember even the types of drinks that you served? Yes, I do. And you remember the number of drinks that you served him? Yes, I do. I served him 3 drinks. Wait, okay, let me make sure I understood your testimony. Your recollection is that you served Billy 3 drinks that night. And bartender says, yes, 3 drinks. All right. So, you remember at the beginning of your testimony here today in trial, you again swore to tell the truth, the whole truth, and nothing but the truth, so help you God. Correct? Yes. And that's what you're doing now, right? You're giving me the truth. Correct? Yes, he says. I'm giving you the truth. And there's nothing hampering your ability, as we sit here today, to tell the truth, right? Correct. Nothing. All right. And what you're telling the jury is you remember that evening and you remember serving Billy 3 drinks. That's what you're telling this jury, correct? And he says, yes. Bingo. You've got him boxed in now. You got it. So, what you would say to the bartender is, you remember coming to my office about 9 months ago, correct? Yes. You remember I took your what's called a deposition that day. Yes. I'll represent to you, this is a copy, an exact copy of that deposition with every single question and answer that we went through that day. I'll represent to you, that's what this is. And he says, okay, I appreciate that. All right. And so I'll come and approach, Your Honor, is it all right if I approach the witness? Yes, it is. All right. Let me show you your deposition, and I'm going to turn to page 12 of your deposition, line number 8. And I want you to read along with me. Question. And remember, this is the sworn testimony that you gave, in other words, just as if you're in front of a judge and jury 9 months ago on this exact case. Question. Do you remember how many drinks that you served Billy that night? Yes, I do. You see your answer? Yes, I do. Right. Next question I ask. How many drinks did you serve Billy that night? Your answer. 9 drinks. Did I read that correctly? And the bartender says, yes, you did read that correctly. All right, well, I would think that the jury at this point is confused. 9 months ago, you testified that you served him 9 drinks. Today, you're testifying that you served him 3 drinks. What's the difference? What has happened? Why? It appears that you've changed your testimony. Can you explain that to me? Bingo. You have now shown with the prior deposition that it is highly likely that this person on the stand is not telling the truth. And so then you, as the lawyer, you can ask a bunch of follow-up questions. Did you happen to have any conversations with this defense lawyer over here? And this defense lawyer has encouraged you to testify in a different way. Or Have you spoken to someone else that has encouraged you to testify in a different way? Or are you saying that your memory back then was not good? Or are you saying that your memory now is not good? So, they go through a litany of excuses with regard to why it is that their testimony is so dramatically different. But at the end of the day, I don't care what the excuse is. During closing arguments, what I'm going to do as the attorney in that matter is I'm going to say, ladies and gentlemen, you saw it just like I did. The bartender testified 9 months ago, he served 9 drinks. Now he says 3 drinks, and he wants you to believe this excuse. What I would assert to you, ladies and gentlemen, is he's not being truthful. He's not being truthful. Or an uglier way to say it would be he's lying. Which version of this do you want to go with? The 9 drinks 6 months ago, when he probably had a better recollection of it, or the 3 drinks now? That's your decision as the truth seeker to judge. Is he lying? Which is the truth? What is not the truth? But what I would assert to you is he's lying. So, my friend that asked me the question, how do you show that someone is lying on the stand? There's numerous ways that you can do it, but the most obvious way is the one that I just went through, which is using your deposition testimony to impeach the witness in front of the jury in trial. I hope that helps everybody.